676-363. State of Ohio versus Leander Bissell. Defendant is in court with counsel. Tim Huber and Daryl Denny. President from the state, Carl Mazzone, Maggie Graham, Diane Nasser. This matter was bench tried to the court. Testimony was concluded on Tuesday early afternoon. I then took a recess. I have reviewed my notes and reviewed the various videotapes, which was the principal evidence in this case. When I was first assigned this case, my initial reaction was that perhaps it was over-indicted and it was a stretch for the state of Ohio. However, this original impression was wrong. After a clear presentation of the facts, this turned out to be the right indictment. The facts were straightforward, as documented by the various videos taken at the scene. A motor vehicle accident occurred at the border of Cleveland and Bracknell. A car was rolled over in the high-speed lane and in the left berm area. Another vehicle was at rest in the right berm area. Immediately, two zone cars from Cleveland Police Department, two zone cars from Bracknell responded to the scene. They set up a transitional zone with their vehicles angled across the high-speed lane, we'll call number 1, in the lane immediately to its right, lane number 2. This was to prevent any traffic from traveling along those lanes. Eventually, traffic was diverted to lanes 3 and 4, and no traffic was traveling in lanes 1 and 2. And the only people present in these first two lanes were the first responders to the scene. Engine 22 arrived shortly thereafter. They parked just east of the accident scene. Firefighter Tetrick, as was his responsibility and duty, went to the right berm area to check on. There was a passenger and a driver who had been involved in the motor vehicle accident. He checked on their well-being and determined that they were in good shape. They had no injuries and responded that they did not need any medical attention. After completing his evaluation of the occupants on the right berm area, Firefighter Tetrick proceeded to go back to lanes 1 and 2 where the accident had occurred. And as he was doing so, he was entirely in lane number 2 when the defendant, traveling at a high rate of speed, struck him and caused his death. The video, various videos clearly show that this is the only vehicle that was traveling in lanes 1 or 2. The videos also show that the defendant skirted around those police vehicles, blocking the lanes of travel. He would go into lane 3, then cut back into lane 2, so he could proceed unimpeded, despite the fact that knowing that there was first responders in that area and the investigation as to the motor vehicle accident was not completed. Additionally, the traffic in lanes 3 and 4 at times were at a standstill or traveling at a very slow rate of speed, with officers directing traffic with their flashlights. Much was made about the element of knowledge in this case, that the defendant did not knowingly cause the death of Johnny Tetrick. Under Ohio law, a person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result or will probably be of a certain nature. It is not necessary that the accused be in a position to foresee the precise consequence of his conduct. Only that his consequence be foreseeable in the sense that what actually transpired was the natural and logical, and that it was within the scope of the risk created by his conduct. This is exactly what happened in this case. Traffic should not have been in lane 1 and 2. First responders were there providing accident investigation, cleanup, and medical assistance. There was no reason for the defendant to be traveling in that lane of travel. And in fact, at one point, the defendant, not only did he skirt around the vehicles by going from lane 2 to 3, at one point, he skirted around one of the police vehicles on the left side between the high-speed lane, lane number 1, and the berm. So this shows that he was well aware of what the situation was at the time of the accident. For those reasons, I'm going to find the defendant guilty of all counts in the indictment. However, there will be a discussion at the time, or just at the time of sentencing, with respect to which counts merge with other counts. That being said, counsel was instructed to file sentencing memorandums, and the court will review those accordingly. In the interim, however, the court finds that the defendant is guilty of count 1, felony murder, with a forfeiture specification, counts 2 and 3, felonious assault, count 4, involuntary manslaughter, count 5, failure to comply, count 6, aggravated vehicular homicide, and count 7, failure to stop after an accident. This matter will be set for sentencing on, I believe it was August 18th at 1 o'clock. August 9th, excuse me, thank you. Anything further at this point, counsel?
Nothing on behalf of the state of Ohio.
Behalf of the defense?
Nothing.
Very good. The defendant is remanded without bond.